This week, we're going to be talking about information gathering, which is part of Chapter 6 in Digital Media Law, 2nd edition by Ashley Packard. Digital media has made most people a publisher in some format. We previously discussed this, and it has expanded the concept of freedom of expression by making information and the means to share it more accessible. This, of course, presents some issues when it comes to the law. Greater access means that there are more types of people and organizations that are getting to gather information and who we have to consider when it comes to the protection of the laws. So there are the group that we always think about, which is our traditional media, newspapers, magazines, radio stations, and TV channels. We know that those are information gatherers. And yes, they have been influenced by digital media, but not to the same extent as these other groups. We also have an increase in civic engagement. These are more of our everyday people who are bloggers, who have podcasts or webcasts, and people who even are just on social media putting information out there. Of course, we have companies. A lot of companies have expanded into editorial. So if you've flown an airline anytime in the last 6 months to a year, you might have noticed something like their in-flight magazine. We have both business to business communication and business to consumer. This is business to consumer, and it's a form of information that they put out externally, but they have other publications internally that have to be considered. We have special interest groups and also professional organizations. Professional organizations, for example, are the Society of Professional Journalists, the SPJ, and the Public Relations Society of America, the PRSA. They're both professional associations within the field of communication, and they, like all the rest of these groups, serve a quasi-journalistic role for people, either everyday people, if we're talking about civic engagement, or for people in specific industries. For us, that would be journalism and public relations, to tell them about changes in technology for doing the job, issues with buying and merging of different companies, and more. This is common across all industries. So with all these different content producers, this raises legal questions about the kind of information we are entitled to have, as well as what we are entitled to protect. As part of this lecture, we will question what it means to be a journalist, what makes someone a journalist, and who should qualify for the privileges and protections traditionally extended to journalists regarding access to information and protection for sources. And this starts with the access to information portion. Access to information is a basic human right recognized by more than 80 countries in 2 international treaties. We have the American Convention on Human Rights from 1978 and the International the International Covenant on Civil and Political Rights from 1966. 80 of these nations have enacted laws to protect the right to receive information, and 53 have expressed right in their constitutions. The Supreme Court has also stated that the right to receive information and ideas is encompassed in the First Amendment. However, we will learn that that is challenged in certain cases when it comes to privilege. In the United States, the Freedom of Information Act facilitates access to government information. Congress passed the law in 1966, and basically it opened records in the executive branch to public inspection. You'll notice that I just said the executive branch and not the judicial or the legislative branch. This is very specific. And it basically provides access to more than 90 different agencies. These include every federal department, the military branches, independent regulatory agencies, government-controlled corporations, and the executive office of the president. When it comes to the freedom of information, act and requesting documents, you should know that the FOIA agent is not required to answer specific questions or to create documents. In essence, they're just required to produce the documents they have related to your inquiry. These may include rules, opinions, orders, files, and proceedings that they have created or control that exist in any format. This could be just regular, Word documents, it could be PDFs, it could be photos, it could be police reports, any of this information. But there are certain documents not included, which are personal notes, papers, and calendars, because they're not considered public documents. So a court will consider the following four um, elements to decide whether something is a public or personal record for the purpose of responding to a Freedom of Information Act. Those four are as followed: the intent of the document's creator to retain or relinquish control over the records, the ability of the agency to use and dispose of the record as it sees fit, the extent to which agency personnel have read or relied upon the documents, and the degree to which the documents was integrated in the agency's record system or files. The Justice Department maintains an FOIA website that provides contact information for all the federal agencies. I encourage you to go to it. It's foia.gov, and you can see here a screenshot of what it looks like in its current state. And it has a variety of different information on it, including a video on how to even file a request, things that you should do before even making a request. For example, things like making sure that information isn't publicly available somewhere else, or that you're able to ask at a lower level for that information. I recommend that you go to this site and look through it, because I think it will make it a little bit more understandable, and you'll be able to get a feel for what goes into the process. In this class, we don't make a FOIA request, but I like to go through the process of a FOIA request and show you an example, because I think it just makes it a bit easier to understand once you've seen one. But I want to start with some key elements. The first is that the Justice Department states all requests must be in writing. The more detailed, the more likely the information officer will be able to fulfill your request. You don't have to specify the documents you want per se, because that may limit what you receive, but you need to provide a description that enables an agency employee familiar with the subject area of the request to locate the information with a reasonable amount of effort. And so you don't have to be super specific, but you do need to be descriptive enough for them to understand. One of the common misconceptions people make is that they have to say why they are requesting the information in their letter. You do not need to do that. In fact, do not do it. The Supreme Court says when documents are within FOIA's disclosure provisions, citizens should not be required to explain why they seek the information. A person requesting the information needs no preconceived idea of the uses the data might serve. The information belongs to the citizens to do with as they choose. Agencies are allowed to charge for the time and duplication cost of your request. However, if you're with a media outlet, you do get your first 100 pages of any request free. And there's a few other specifications that are made. This also starts to get to the idea, well, who is a news outlet? What makes someone a part of a news outlet? And we'll get to that in just a few minutes. There are also some exemptions that have to be considered. FOIA exemptions include requests that could endanger national security, include internal agency personnel or violate internal agency personnel rules and practices, information exempted from disclosure by other statutes, trade secrets and commercial or financial information that is privileged or confidential, interagency or intra-agency memos, so two different ones, that wasn't a mistake, interagency or intra-agency memos or letters that would not be available by law to a party other than an agency in litigation with the agency, personnel and medical files or similar files that would involve an unwarranted invasion of privacy to individuals, investigatory records of law enforcement, reports prepared on behalf of agencies that regulate or supervise financial institutions, and geological and geophysical information. There are rules related to how long the government has to respond to your request. However, it is not always fully enforced or followed. An agency has 20 days to fulfill or deny your request. But as many journalists learn, you often have lengthy back and forth with the agency before getting the information because the agency may deny it without grounds, or they may approve your request but redact nearly all of the information. On the screen right now, you will see an example of a FOIA request. This is a request that Sydney Lumpkin, who works with NPR, presented at the Association of Healthcare Journalists conference in 2009 in their special section on media access to health information. I found her example through the association, and I am sharing that here with you today to show you the basics of how she writes the request. This is also available in our links on Canvas. You will see here that she starts. The red is information that isn't really in there. It's just directions giving you a little bit of help about how to go about this. Of course, you want to direct it to the right person. The FOIA website has the contact information for the different agencies. However, this is at the state level and not the national level. So she wanted to make sure that she went and found the right person to direct the information. And then, of course, she gave a pleasant greeting. She starts with what she is going to be requesting, but she also includes the law that allows her to request those records. Pursuant to the North Carolina Public Records Law, and then she gives its citation, I hereby request the following records. And now she's going to tell what records and what time period she's interested in. All of the DHSR survey reports for the Park Ridge Health in Hendersonville, which may also be listed as Fletcher Hospital, Inc., pertaining to restraint and seclusion from 2000 until the present day. I'd also like correspondence between DHSR and the hospital related to these reports to learn whether the hospital made any changes. So we now know, here's the law that allows me to make this request, and here is what I'm requesting. And I'm requesting it from 2000 until today. The next part is she's going to give instructions for denials. Sometimes you hear back within 20 days and it is a denial because they don't want to give the information. So she's saying that I would like you to tell me why. If any part of this request is denied, please cite the specific statutory exemptions which you believe justifies your refusal to release the information. Inform me of your agency's administrative appeals procedures available to Vice News under the statutes. And then she mentions the fee waiver. And I'm just going to read the highlighted part. Please advise me in advance of the estimated charges associated with fulfilling this request. Please send me a detailed, itemized explanation of those charges. As I already noted, you're supposed to get the first 100 pages free, but you need to ensure that they're not going to request an outlandish amount beyond that. And you don't know how many documents you're actually going to be getting, so that number could be quite a lot. So now she's going to ask for electronic records and ask that she be called. In the interest of expediency and to minimize the research and or duplication burden on your staff, please send records electronically if possible. If this is not possible, please notify me before sending to the address listed below. Since time is a factor, please communicate with me by telephone or this email address. And then she provides the information. And then, of course, you need to remind them how long they have to fulfill your request. Our book says they have 20 days. However, this is not always upheld. So my understanding is that open records law requires that you respond to and fulfill this request as promptly as possible. Remember, this is at the state level and not at the federal level. If you expect a significant delay in responding to and fulfilling this request, please contact me with information about when I might expect copies or the availability to inspect the requested records. So she wrote all that out. You can see kind of how you structure these. There is no specific form that you use. There's no specific way that you write these, but I think this is a really good example that Sydney provides. Sydney also notes that she sends birthday cards to her FOIA requests each year, meaning that she has requests that have been out there for 1, 2, 3, 5 years that she's still waiting to hear from, because a lot of places go with as promptly as possible and take that to mean however long they want. Now, Sydney did hear back, and she received this, a file that was almost entirely redacted information. This is not very helpful, but it's also very common. When I worked for the newspaper, we would get police reports, and sometimes you would go and you would essentially get this same file of police reports with almost all the information redacted other than the crime. Along with the documents that Sydney received, she also got this message. We redacted a number of details related to protected health information under the HIPAA privacy rule, where we felt there was a reasonable basis to believe the information alone or in combination with other information could be used to identify an individual in a treatment facility or their confidential information. So that's the response. So she replies back to this person. The North Carolina DHHS, so this is the Department of Health, is not a covered entity under HIPAA in its role as a surveyor because it is not providing health care, it is not a billing service, and it is not a health plan. As such, the privacy rule does not apply and is an exemption to the North Carolina Public Records Law. And so you can read kind of the rest of it. You might need to pause it to read it. And you can see that there often is a lot of back and forth when it comes to requesting information. Part of the Freedom of Information Act also includes that it is for representatives of the news media. This is important because it starts to help us define who is the news media. And they say it's any person or entity that gathers information of potential interest to a segment of the public, uses its editorial skills to turn the raw materials into a distinct work, and distributes that work to an audience. It also defines news as information that is about current events or that would be of current interest to the public. Unfortunately, issues have plagued the FOIA system since the beginning. So there have been attempts to fix this issue, but you can see in 2010, the federal government spent $201 creating and securing old secrets for every tax dollar spent declassifying. In 2007, the Open Government Act was passed by Congress in response to withholding of information post September 11, 2001. And the amendment made federal agencies more accountable to FOIA requesters, and it required agencies to do these 5 things. Assign tracking numbers to requests that take more than 10 days to process. establish a phone or internet system requesters could use to check on the status of their request, provide a public liaison to assist in the resolution of disputes between the agency and FOIA requester, to establish an office, which they did, and have agencies submit annual reports to Congress detailing their FOIA activities. However, the responses to requests were and still are very slow. The Obama administration set to help that in 2009 when they set into motion the Open Government Initiative that pushed agencies further to be more transparent and collaborative. Training materials were updated, more guidance was given, and a national declassification center was developed to streamline the declassification process. This did improve speed, but there is still much to be done. You may remember when Donald Trump was running for president, there was a lot of discussion among citizens and the media wanting him to release his tax documents. While President Obama was in office, there was also a lot of discussion about having Obama produce his birth certificate. The reason neither of these things had to happen, despite or the media's ability to file a FOIA request, is that FOIA applies to the executive office of the president, but not to the president or his or her immediate staff. The conference report for the 1974 FOIA amendment states, the president's immediate personal staff or units in the executive office whose sole function is to advise and assist the president are not included within the term agency. So far in this lecture, I've been talking about the Freedom of Information Act at the federal level. Now it's important to talk about state freedom of information laws. All states have statutes giving the public access to state records, and 10 states include right of access in their constitutions. But the laws vary from state to state, which is important to remember. I was a journalist in Florida before moving to Alabama, and I believe that being a journalist in the state of Florida is one of the greatest states where you can be a journalist because they have very good open records policy. For example, journalists can request the voter database be sent monthly to them for a $5 nominal charge. You can also readily find this available on the internet. There is a website that tracks every registered voter. It doesn't tell you how they voted, but it tells you their name, their address, what party they're registered with, if they're registered with a party, and their age, when they registered, and that type of information. It also makes it easier to keep an eye on our lawmakers in the state of Florida. Though in Florida it has come under debate whether or not these open record laws are necessarily good for the people, because there is something called Florida Man, which is basically a search term that people use to find stories about people who have done weird, odd, and sometimes crazy things in the state. And people think it's because of our easy access to information related to crimes and misdemeanors of any sort that we're able to get those stories. State records are available to anyone who requests them as well, which is always important to remember. While there's a lot of publicly available information out there, many who report on issues related to public concern will eventually gain access to information that is proprietary, confidential, or even illegally obtained. Not necessarily illegally obtained by the journalist, but by someone else who then gives it to the journalist. From a legal perspective, access to such information raises two really important questions that we have to consider. The first is whether that information can really be reported, and whether the source of the information can be protected. In this 2001 case, Bartnecki versus Vopper, we start to look at the answer to that first question. So in this 2001 case, Bart Necki, her name's Gloria. She was the chief negotiator in a upcoming teacher strike in Pennsylvania. She was making a phone call to the president of the teachers union that was intercepted and broadcast on a local radio station by Frederick Vopper. Vopper claimed that he received the tape of the conversation from a man who found it in his mailbox. And Vopper decided to play the tape on the radio in conjunction with the news coverage regarding the strike. So the Supreme Court had to decide whether the broadcast of an illegally intercepted telephone conversation violated state wiretapping laws. And the court acknowledged that in this case, it did violate the wiretapping and electronic surveillance statute. But other circumstances that helped them decide was whether or not the application of statute violated the First Amendment based on three factors. One, the respondents played no part in the legal interception of the material. Their access to it was lawfully obtained, and it concerned a matter of public interest. So what it comes down to was it did break one rule, but because of these other three elements, it was deemed that the First Amendment protects media disclosure of illegally intercepted information as long as the information concerns issues of public importance and the media do not participate in the illegal interception. How this applies to non-traditional media or the publication of classified documents is still unclear. Bart Necki versus Vopper was not concerned with national security. It was more related to respect of privacy. The legality of publishing classified documents remains to be resolved. Under the Espionage Act of 1917, it is a crime not only to take information relating to the national defense, which the possessor has reason to believe could be used to harm the U.S., but also to receive or communicate that information knowing it was taken without authorization. This statute could be used to punish the media for publishing sensitive information, but so far it has not been used to do so, which is important to remember. Something that I think is really important that we talk about is journalist privilege. And at the root of journalist privilege is the ability for journalists to protect their sources by not identifying them to the consumer or the government. This allows journalists to gather necessary information to keep the public informed that they may not be otherwise able to share or even get. And of course, there are a variety of instances when journalists need anonymous or unnamed sources in order to get information for stories. And I think we all, can think of a few examples or when we've seen an unnamed source in stories. So one of the big ones is journalists want to protect their sources from retribution. Sources who share information about criminal activity may be harassed or harmed by criminals who want to keep that activity secret. This happens sometimes if you get information about gang-related violence or gang-related crimes, and the person who gives out the information could be seen as a snitch, and then they might be hurt or even killed by members of that gang for doing so. We also have the well-known term whistleblowers. So these are people who expose their employers for engaging in illegal or unethical actions. And of course, if it gets out that they were the whistleblower, they may be punished or fired by employers for sharing information with the media. Government employees get practically no whistleblower protection in the United States. But there is something called the False Claims Act, which protects federal employees who report government fraud. However, it doesn't protect them from retribution um, of other sorts that could lead to loss of job. Some sources may also be participating in illegal activities that they don't necessarily want the government or police to know about, or they obtain that information through participation in an illegal activity. There are reasons that a journalist may protect their source because the source wants privacy. This is often related to health information. They may be willing to talk, but they don't want to be named because they don't want people to know about a certain health condition they may have. People were really surprised when Magic Johnson, the basketball player, years ago now, disclosed that he was HIV positive. This is the type of information that often people wanted private. They didn't want other people to know about. So it was really a big step for such a public figure to come out and say he had been diagnosed as having HIV. Journalists also do not want to be seen as tools for law enforcement. That's what it could make journalists more at risk of being harmed, of course, but also discourage sources from talking to them in the first place because they think that it's going to be reported back, whether or not they're doing illegal things or not. Media companies have been sued for revealing their sources' identities. Sources who were promised confidentiality and were later betrayed have earned court sympathy. The Supreme Court held that a source may sue a reporter who violates a promise of confidentiality for promissory estoppel, which is a tort basically violating an oral contract without infringing on the First Amendment. Journalist privilege comes from three sources: shield laws, common laws, and constitutions. And this is really based on different jurisdictions. Journalist privilege mostly comes from shield laws. Those are statutes that entitle journalists to protect the identities of their sources or other information collected. But while there is no national shield law, 40 states have shield laws that offer varying levels of protection. I am very glad to tell you that Alabama is among those states. Where legislatures have not acted, courts have by finding qualified privilege within state common law or adopting within their own rules and procedures. And then there are two states, California and New York, that have included provisions of journalist privilege in their constitutions. So this is not surprising that it is these two states because they are considered two of our more liberal states. So I think that's always important to note. Whether journalist privilege is protected under the U.S. Constitution is debatable. Although journalists argue that the First Amendment protects journalist privilege, courts are not unanimously convinced that it does. And the Supreme Court rejected the notion that the First Amendment protects journalists from having to testify before a grand jury in a 1972 case, Brazenberg versus Hayes. However, many lower courts believe it can be applied in other circumstances. Who is a journalist? This is a complicated question and a big, important question. It was once easy to tell because they worked for a traditional news outlet, a newspaper, a TV station, a radio station, a magazine. Luckily, the Supreme Court has provided some guidance for us by saying freedom of the press is a fundamental personal right, not confined to newspapers and periodicals. It necessarily embraces pamphlets and leaflets. The press, in its historic connotation, comprehends every sort of publication which affords a vehicle of information and opinion. So it gives us a bit of wiggle room that we needed as technology has changed over time and redefined news organizations and the people who disseminate news. because we have our traditional news outlets, but then we have digital native news outlets. Those are ones like slate.com, news outlets that emerged on the web and exist solely on the web. We have organizations that have come out with apps or started as apps and have transitioned. We, of course, have people who maintain blogs, and blogs these days look a lot more like websites than ever before. Of course, microblogs like Twitter exist, and all of this blurs the line of who is a journalist because there are so many content creators, and determining who is a journalist gets complicated, especially in the eyes of the law and those who do and do not get protection. So, what do the courts have to say about this? The Ninth Court says what makes journalism is not its format, but its content. And the critical question for deciding whether a person may invoke the journalist privilege is whether he or she is gathering news for dissemination to the public. The Third Circuit Court says a journalist is someone who is engaged in the news gathering process and who possesses the intent at the beginning of the news gathering process to disseminate the information to the public. The Second Court has said that an important factor is collecting information for the purpose of independent reporting and commentary. So, based on this, many bloggers, filmmakers, and information providers should qualify. But do they? One of the growing groups of communications professionals is bloggers. And more states are now offering privileges to non-traditional journalists and bloggers that they once held more sacred for traditional journalists. For example, a court in California, or appellate court, was one of the first to conclude that online journalists enjoy the same right to protect services that offline journalists do. However, cases in New Jersey and Oregon both denied bloggers those protections to their sources. In Oregon, the court noted that the blogger was not affiliated with any medium as part of the defense. However, there were other issues with the Oregon case related to the defense of negligence. States are more likely to apply journalist privileges to bloggers who show evidence of professionalism. However, of course, there's a question of whether or not all journalists are having the same level of professionalism. If you've been keeping up with the news in the United States, recently Peter Alexander, an NBC reporter, was criticized by some for how he asked a question to the president, and the president gave a pretty terse and not particularly appropriate response. And some people say, well, Peter Alexander wasn't acting appropriately, even though he's a journalist with a major news organizations, whereas other people say Peter Alexander was acting professional, but it was the president, Donald Trump, who was not acting presidential at the time. The Privacy Protection Act of 1980 was meant to shield journalists' work products and materials from newsroom searches used to skirt delays normally associated with a subpoena. But the law's wording does not specifically refer to newsrooms, and if interpreted at the service level, should apply to bloggers. I have it written below here. So it says, notwithstanding any other law, it shall be unlawful for a government officer or employee in connection with the investigation or prosecution of a criminal offense to search for or seize any work product materials possessed by a person reasonably believed to have a purpose to disseminate to the public a newspaper, book, broadcast, or other similar form of public communication in or affecting interstate or foreign commerce. What do you think when you read that? Thank you for your time today. I hope that you found this chapter interesting. I hope that you found the information from this lecture helpful. And as always, I want to provide just a few questions for you to consider. But before that, I want to let you know I've really enjoyed reading your weekly responses, but I also want to remind you to comment on your classmates' post. So here are the 4 questions this week. What does the Freedom of Information Act do? And what is an agency under the Freedom of Information Act? How can people get information about the legislative and judicial branches? Does the First Amendment protect journalists' privilege? And are bloggers protected by journalist privilege? Does the Privacy Protection Act of 1980 apply to them? Why or why not? I want to know what you think about that in your responses this week.